Hi, I'm Malcolm Burrows, Legal Practice Director of Dundas Lawyers. I'm here to talk to you tonight about the top 7 mistakes people make when putting together shareholders agreements. Shareholders agreements, or business wills, as I recently heard them referred to by Paul Betty of the Australian Financial Advisors, are commonly created at the beginning of a business relationship. They attempt to regulate the conduct of the parties who are going into a new venture and apply to a wide variety of commercial structures, not just Pty Ltd companies. I've personally put together dozens of such agreements and seen various oppressive ones where I've had to fight for the rights of minority shareholders. But it's with the experience of both an entrepreneur and a corporate lawyer that I've put together the top mistakes I've seen from people putting together shareholders agreements. The first mistake is not having one. Oftentimes, in the excitement of establishing a business, promoters feel that the cost of preparing a thorough shareholders agreement is prohibitive. This may be the case, but let me assure you that in my experience it costs about 20 times more on average to attempt to fix the problem after the fact than it does to address the issues properly beforehand. What's worse is that there's no guarantee that it can be fixed at all. Nowhere is the old adage, prevention is better than cure, more applicable in this case. The second mistake is not considering a tailored constitution. Depending on the situation, it's possible that a constitution can be tailored to take into account the particular issues faced by the business. The benefit of this approach is that if a company is raising capital from shareholders via a prospectus or pursuant to the 1220 rule, they don't have to have shareholders sign another document. In other words, there's less paperwork. The downside is that a constitution can be amended by passing a special resolution of the members, whereas all shareholders must agree to amend a shareholders agreement. It's a case of ease of administration versus more protection. The third common mistake is what I call, we've known each other for 10 years, what can go wrong? If I had $1 for each time I've heard this, I'd probably have about $30. But let me assure you that in the absence of a shareholders agreement, as soon as the business runs into trouble or is making a good return, 10 years of trust evaporates in a heartbeat. The fourth common mistake is that people assume that the Constitution and the Corporations Act will protect them. It's a common misconception. But the short answer is that the governing legislation doesn't actually cover a wide variety of conduct that the parties can engage in. I must have 100 war stories in this regard that will probably form the basis of my next YouTube video. The fifth mistake is not considering the impact of future events. Now, when raising capital, for example, it's usual for shareholders to dilute their holdings as shares are issued in exchange for cash. This means that the voting power they can exercise shrinks proportionately as each share issue takes place. What this means is that a major shareholder's ability to pass certain resolutions is often overlooked. It may mean that a shareholder could lose control. The sixth common mistake is not thoroughly considering all of the issues. Let me assure you there is an absolute plethora of legal issues that need to be considered by shareholders to properly analyse and prepare for the situations that can arise. That said, if all the parties are fully informed and the provisions are drafted appropriately, the shareholders' agreement should be able to sit in the bottom drawer gathering dust until a situation arises where it needs to be consulted. Dundas Lawyers has devised a process for preparing shareholders' agreements that aims to educate and streamline what can be an otherwise expensive process. This process starts with an education session and some fact-finding on the background of the business, then proceeds through a structured questionnaire and finally to the drafting of the document itself. This process is available in both a workshop or seminar format and on a one-on-one basis, with the workshop format being clearly more cost-effective. The final mistake is mistake 7, which is not planning involuntary succession. Most issues that we prepare for our lawyers fall into what we call the voluntary succession category, where the parties no longer agree and one or both decide to exit. Yes, Paul, I agree. Rarely is death or total permanent disability considered by people, and rarer still is it insured against. Yet again, rarer still is those people who fully consider the tax consequences in the event of the death of a shareholder. With a solid basis of having seen mistakes firsthand, we build a solid framework for our clients to build shareholder value on. Dundas Lawyers drafts and settles a wide variety of shareholders agreements for a variety of entity types. So for further information on how Dundas Lawyers can assist you to build shareholder value by ensuring your business is on a solid foundation, please feel free to contact me personally. Thanks for watching.